imagine for 1 second what a speech from a former president normally looks like. Maybe it's the opening of a presidential library, maybe it's a university commencement. You get the idea. And then there are speeches from our most recent former president. Before I show you his speech today, I have to warn you, it is vulgar. But we are going to play it uncensored for reasons that I will outline after we play you this sound. So prepare yourself.
I'm sorry, I won't be able to go to Iowa today. I won't be able to go to New Hampshire today because I'm sitting in a courtroom on bullshit because his attorney general charged me with something. Terrible.
That was the former president of the United States, President Donald Trump, in New Hampshire today, calling the multiple criminal indictments against him very serious charges. That was Trump characterizing those indictments as BS. Now, I'm not bringing this up just because Trump was unhinged in New Hampshire today, but because how unhinged Donald Trump is may actually substantively matter for these court cases. You might remember that last Friday, after Trump posted on his social media website, "If you go after me, I'm coming after you." After Trump posted that, special counsel Jack Smith asked the judge in the 2020 election case to issue what is known as a protective order, limiting what Trump can and cannot say publicly. And here was Trump today, talking about that very same protective order.
Crooked Joe now wants the thug prosecutor, this deranged guy, to file a court order taking away my First Amendment rights so that I can't speak. So listen to this. We don't want you to speak about the case. The case. I will talk about it. I will. They're not taking away my First Amendment rights.
I will talk about it. I will. Now, we should make clear here that this isn't Jack Smith saying that Trump can't talk about this case at all. This is Jack Smith asking very specifically that Donald Trump not be allowed to do anything that could intimidate or threaten anyone involved in this case. And we do not have to imagine what that might look like. Trump's legal team has already laid it out. In its own filing yesterday, Trump's defense team literally crossed out, strike through text, certain lines of the prosecution's proposed order. The defense doesn't think Trump should be barred from publicly releasing things, including recordings, transcripts, interview reports, and related exhibits of witnesses. He will talk about it. He will. So today, the judge in that case, Tanya Chutkin, scheduled a hearing on Friday at 10 a.m. in Washington, D.C. to settle this matter. But my question is, what happens if Trump is ordered by a federal court not to talk about something like this, but then just does it anyway? Presumably, there's some legal peril in Trump's strategy here, but that does not seem to be stopping the man. In fact, on top of all of this, there might possibly be more indictments to come. Today, the same grand jury that indicted Trump last week was spotted meeting again in D.C. Grand juries cannot continue meeting on indictments that have already been charged, so this would be something else. This would be something new. And that comes after we got this very great reporting from Betsy Woodruff Swan at Politico. On Monday, Jack Smith's prosecutors had a closed-door interview with a friend of Rudy, Bernie Kerik. And they asked Mr. Kerik multiple questions about how Trump's PAC, Save America, raised enormous amounts of money in the weeks between the election and January 6th. You may remember that Trump raised more than $250 million in the 8 weeks after the 2020 election, and he did so by running ads like this one.
America deserved an honest election. This is what they got. Suitcases of ballots added in secret in Georgia. Dead people voting in Wisconsin. A money for vote scheme in Nevada. Poll watchers denied access in Pennsylvania. Faulty ballot drop boxes, and clerks facing felony charges in Michigan. The evidence is overwhelming.
For months, well before Trump's latest indictment came out, we had seen report after report that special counsel Jack Smith was investigating Trump's use of false claims about the election to raise money. We even had reporting that Smith was particularly interested in seeing if any of that activity amounted to wire fraud. And now it looks like we have confirmation that part of Jack Smith's investigation the part that deals with potential wire fraud, campaign finance fraud, that part is very much ongoing. The special counsel may very well not be done here. And that may be a good call on Jack Smith's part, because the former president is not done lying.
There was never a second of any day that I didn't believe that election was rigged. It was a rigged election. It was a rigged election, and it was a stolen, disgusting election. And this country should be ashamed.
Joining us now are Politico national correspondent and MSNBC contributor Betsy Woodruff Swan and former federal prosecutor and co-host of the Prosecuting Donald Trump podcast, Andrew Weissman. Thank you both for joining me tonight. Andrew, are we going to see a superseding indictment here, or do you think this grand jury action is about the co-conspirators who were unnamed in the initial indictment?
Well, I think that the odds of seeing a superseding indictment in the January 6th case against Donald Trump are low. And that's because it's clear that the prosecution wants that to go to trial, and they want a trial date, and they want it to be either before the election or even before the Republican nomination. But what we could see is, to your point, the co-conspirators. I think it's highly likely that some, if not all, will be indicted, but that can be in a separate case. And then on the financial piece, that also could be a separate set of charges. And that doesn't necessarily need to go all the way up to Donald Trump to bring that case. Remember, that case is very similar to the cases that we saw against Steve Bannon and his cohorts in connection with Build the Wall, which was basically just a fraud case, which is you raise money saying X when you really meant not X. And you could have the same thing. What I find really interesting, if that proceeds, is that can lead to pre-trial forfeiture. We did this in the Mueller investigation, and so you could end up with that PAC with the money being frozen.
The Save America PAC.
Exactly. And what is it being used for?
Legal bills.
Exactly. Sorry. Exactly.
We take it on the road. Wait a second. I mean, that's deeply problematic given the fact that this is effectively the piggy bank for all the defendants that are thus far towing the line for Donald Trump. This is where their lawyers, we think, are being paid from. So to have those funds frozen would have significant legal implications.
Yeah, I mean, there could be other funds that are available, but if they're funds that have been obtained by fraud, and obviously the government would have to prove that, there's a showing that needs to be made, but you can get pretrial seizure orders. We did that in the special counsel investigation. Obviously, that all requires proof. It requires a court to do that. But if this is where they're going, you can do that, and there doesn't have to be a charge against Donald Trump. It can be against the PAC itself. It could be against lower level people and still have both civil and criminal forfeiture.
If you were watching Fox News on Sunday night, you may have heard Donald Trump's former attorney, a man named Jim Trusty. You may have heard him offer up a novel theory about the classified documents case against the former president.
There's a lot of shenanigans in terms of grand jury usage. You know, you don't do a grand jury investigation for a year only to move it to another district unless there's more to the story. There'll be litigation, I assume, that relates to these issues of how the grand jury was used or abused. But it's certainly, again, new territory when DOJ shifts an investigation at the last minute to an entirely different venue.
Okay, so that's Mr. Trusty floating the idea that the special counsel's use of a D.C.-based grand jury, the one that has heard this case for months, that is somehow suspicious, and that somehow prosecutors abused the use of this grand jury, and that abuse should be litigated before a judge. Now, enter Aileen Cannon, the U.S. District Judge overseeing that classified documents case down in Florida. The day after Mr. Trusty laid out that argument on Fox News, Judge Cannon issued this ruling with no prompting from Trump's defense team. She just did it on her own. Judge Cannon pointed to the prosecutor's use of an out-of-district grand jury, the one in Washington, D.C., to continue to investigate and or seek post-indictment hearings. And she deemed the use of that grand jury suspicious. Judge Cannon questioned the legal propriety of that move, and she ordered special counsel prosecutors to explain themselves by August 22nd so the issue may be litigated. Now, either there is a really unusual psychic connection between the Mar-a-Lago judge and one of Trump's former lawyers, or back with us is Andrew Weissmann, former member of special counsel Robert Mueller's team, co-host of the Prosecuting Donald Trump podcast, and the man, credit where credit is due, who came up with that theory that Judge Cannon's surprise ruling just might be related to Jim Trustee's on-air arguments the day before. Also joining us is Joyce Vance, former U.S. attorney in the Northern District of Alabama and current professor of the University of Alabama, at the University of Alabama. Joyce and Andrew. Andrew, let me just first start, because you're the person that put together this appearance on Fox News where Jim Trustee says, D.C. grand jury, Florida grand jury, these two things can't mix. And then Judge Cannon mysteriously coming out with the sort of mirror of that argument in one of her rulings. What's going on here?
So first, regardless of how she got there, the fact of what she did is, to say the least, unusual. She did it, as you noted, on her own, and it showed a fundamental misunderstanding of basic 101 criminal law as to how grand juries work, which is they can continue investigating ongoing crime of either an existing defendant or other defendants and other crimes that may be committed. So this is a classic case. It is also the case that you can bring a grand jury investigation in any district where the crime may have occurred. Remember, when you start an investigation, you don't even know if a crime has occurred or who did it or where it occurred. So you're allowed to go to many different districts where it could be the case, as long as you have a good faith basis. So this was such a fundamental misunderstanding. And what I was thinking about is, where in God's green earth is she getting this idea? Because it's so off the charts from everything in the record. Why is she doing this? It's not like the litigants raised the issue. She's doing it on her own, and it's so wrong. And then there you have Jim Trustee, the former president's former counsel, raising this issue the night before, and that morning she issues this. So it's a real issue in terms of people who think that Judge Cannon may have learned her lesson, and this might be Cannon 2.0. She's really changed since the 11th Circuit struck her down twice. This suggests
not so.
This is still Cannon 1.0.
Yeah, very much, or just Cannon 0.0 beta testing. Joyce, what are the implications here? I mean, do the prosecutors face any kind of repercussions here, or is this so unfounded and so, for lack of a better term, bonkers that nobody's going to really take it seriously? I mean, could this affect the use? Could this affect any of the materials derived from the closed-door testimony of the grand jury in Washington, D.C.?
No, it won't have any impact on that grand jury investigation. Alex, I think bonkers is a pretty good word to use to describe this argument. And Andrew, we may have even been in this situation at one point. It's not unusual to have different U.S. attorneys' offices commencing investigation because both of them are seeing some form of a crime at the same time. Both offices investigate until they bump into each other, and then they'll resolve the issue of which district will move forward with what charges. Nothing improper about having those grand juries operating at the same time. But beyond this idiosyncrasy that Andrew has pointed out in the argument that the judge raises, it's not just that she raises it, it's the context that she does it in. Because the government has asked for a Garcia hearing. That's a hearing into a conflict of interest between one of the defendant's lawyers and his client. This is Walt Nauda's lawyer, and he represents some of the folks, or has represented in the past, folks who will be witnesses in this case. So the government asked the judge to set what's called a Garcia hearing so that they could go into open court and put that on the record with the defendant present. Some defendants will hear that their lawyer has a conflict of interest, and they might choose to reconsider that representation. You know, I don't want to be too suspicious here. I just find it to be passably odd that the judge has taken a motion that's supposed to be about one thing And she's come up with this crazy theory, and instead she's trying to make it about that. So I'll throw a little bit of oxygen onto the flames of the argument that Andrew is making.
Well, please do, Joyce, because I think even to the layman, this seems deeply problematic. I mean, it's not just, it's more than, I mean, this is a judge who has not had almost any trial experience. She's very young, and lots of young people with not a lot of experience do extraordinary things, but thus far, her batting average is not good. And is there cause to maybe ask for another judge at this point if you're a prosecutor on this case?
So, Alex, it actually gets worse than what we've discussed so far, because the government submitted to her some information about these other people who were cooperating for the Garcia hearing that Joyce talked about. And that was grand jury material. And the judge said, why was this submitted to me under seal? You didn't set out a basis, and struck them from the record. The basis, I'm sure Joyce and I had the same reaction, which was after our jaws clattered to the ground. The basis is grand jury secrecy. I mean, that is, again, 101. There's no more that you need to say. And the second part is she then said something about where the other investigation was, which is also grand jury secrecy. So the government has to be thinking, what do we do at this point?
Yeah, and Joyce, to that end, I mean, the thing that sort of rescued the special master debacle was the 11th Circuit, not known as a bastion of liberalism. Do you think somehow they get involved in this? I mean, there are plenty of Trump-appointed judges on that, but they seem to understand the law in a way that Judge Cannon does not.
So I think we know that the special counsel does not want to have to go to the 11th Circuit. He's trying to focus straight ahead, getting his case to trial. But that said, there are some things that happen where you can be forced to take an appeal to the 11th Circuit, and it's a court that's well-versed in handling a very prompt emergency appeal. So I think we could possibly see an appeal here on the issue that Andrew has identified, this notion that she won't let them put evidence that has to do with grand jury proceedings into the record under seal. Again, that's a pretty standard thing to do. And they may have to appeal her, and an appeal like that would be a good time to raise the recusal issue if they're so inclined. But, you know, this is not an inexperienced judge when it comes to the way of federal prosecutors, because before she became a judge, she was an assistant United States attorney in the Southern District of Florida. She served in that appellate division. She knows how a grand jury works. It's tough to believe that this was just a simple mistake.
Ooh, a little edge of nefariousness injected in the end right there. Andrew Weissmann, Joyce Vance, no two better people to weigh in on this topic. Thank you guys both for your time and expertise, as always.
We have breaking news at this hour from the New York Times under the headline, Secret Memo Laid Out Strategy for Trump to Overturn Biden's Win. The New York Times is reporting on a memo that was cited in Jack Smith's indictment of Donald Trump. This is a memo that was never found by the January 6th committee. It is from an attorney named Kenneth Chesebro, and it says that the New York Times reports a copy obtained by the New York Times shows for the first time that the lawyer, Kenneth Chesebro, acknowledged from the start that he was proposing a bold, controversial strategy that the Supreme Court likely would reject in the end. But even if the plan did not ultimately pass legal muster at the highest level, Mr. Chesebro argued that it would achieve two goals. It would focus attention on claims of voter fraud and, quote, buy the Trump campaign more time to win litigation that would deprive Biden of electoral votes and or add to the Trump column. Mr. Chesebro cited writings by a Harvard Law professor, Lawrence H. Tribe, to bolster his argument that the deadlines and procedures in the Electoral Count Act are unconstitutional and that state electoral votes need not be finalized until Congress's certification on January 6th. Mr. Chesebro had worked as Mr. Tribe's research assistant as a law student and later helped him in his representation of Vice President Al Gore during the 2000 election, calling his former mentor a key Biden supporter and fervent Trump critic. Mr. Chesebro cited what he described as Mr. Tribe's legal views, along with writings by several other liberals as potential fodder for a messaging strategy. It would be the height of hypocrisy for Democrats to resist January 6th as the real deadline, or to suggest that Trump and Pence would be doing anything particularly controversial. He wrote. Joining us now is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Professor Tribe, you're right in the middle of tonight's breaking news story by the New York Times, which I know you've had time to read. What is your reaction to what you've discovered about yourself in this memo that the Times is just reporting on?
Well, I have to say I didn't recognize myself, and I haven't often been fodder for anything. What Ken Chesebro did was take stuff that I had said in the year 2000 about Florida, and that Florida law didn't set a deadline just before midnight December 12, but allowed counting all the way up until January 6th, the date of the joint session, and in fact, maybe even beyond. That was about Florida law. Remember, Tim Russert said that the 2000 election all came down to Florida, Florida, Florida. Well, this was not Florida, Florida, Florida. It was Wisconsin, Georgia, Pennsylvania, a number of other states. I never said anything remotely like what Mr. Chesebro cut and pasted some of my words to make it sound like I had said. I never said or suggested or would even be caught dead thinking that Congress didn't have power through the Electoral Count Act to dictate how the process is supposed to be conducted on January 6th. So he was scouting around. My little piece in Just Security today that was quoted in the New York Times is called Anatomy of a Fraud. It does turn out that the fraud was Kenneth Chesebro. He dreamed it up. He's a lot smarter, actually, unprincipled, it turned out, but a lot smarter than John Eastman, who I don't think could have come up with all of this. Basically, he plotted how to take a little snippet here and a little snippet there, and through a kind of recombinant DNA, made up a bunch of non-law, which would not only be rejected by the Supreme Court 9-0, but just made no sense at all. So, I guess I'm flattered to be fodder, I suppose, but it just shows how fraudulent it all was and how no reasonable lawyer could possibly believe it. This is not like giving legal advice. Lawyers can give advice, but when lawyers help to build a machine to tear down the republic and the government and to prevent the transition of power by, among other things, making factually false statements. A lot of statements in that memo, the newly discovered one, and in one that had also featured in the indictment, a memo that Chesebro wrote on November 16th, when it had become clear that even the lawyers for Trump said that they had lost Arizona and therefore by their own count they'd lost the election. In the November 16th memo, he had laid out all of the groundwork for this elaborate plot to use phony electors, meeting in places that were not legal to meet, signing certificates that were fraudulent. The whole thing was factually false and legally inventive, but completely empty. That's what the House of Cards is all about, and we almost lost our republic over it. Thank God for people like Mike Luttig, who persuaded the vice president that he couldn't go along with the plot.
Your former student, Mr. Chesebro, is listed as a co-conspirator, not by name, in Jack Smith's indictment, and he says when he's offering this, I don't want to call it a legal opinion. When he's offering this tactic, he says, of course, the Supreme Court will knock it down. The Supreme Court will not uphold it, but it will buy us time. Now,
right.
That is not that is a political tactician's advice. That is not a lawyer's advice.
That's right. He basically said we can buy time. And what is it time for? It's time for the vice president to exercise a power he doesn't have and send things back for a 10-day delay on the 6th of January, right up until 4 days before the inauguration. Send them back so the state legislatures can exercise some magical power, regardless of what Congress says, regardless of the slates that had already been certified by the governor, to name new slates. That is basically buy time to make the coup work, buy time so that perhaps with the violent pressure that we put on Mike Pence with that hangman's noose hanging there, buy time so that we can pressure Pence to violate the Constitution. It's really staggering. And the people like my friend and colleague Jack Goldsmith who say, oh, it's not a good idea to bring this indictment, it's very difficult. I couldn't agree more with Neil Katyal that for this indictment not to have been brought would really be to give up on the democratic experiment for good. Because if a president can use all of his powers, even when he loses an election, to get some creep like Chesbrough to use his law license to help him stage a bloodless coup, and then if it doesn't work, have blood spilled in the streets. If that's our fate, then we are not going to be able to have a self-governing life. We will be living under tyranny, and I don't want to live under a tyranny. I don't think any of your viewers do.
If Mr. Chesbrough testifies in this case or becomes a criminal defendant at some point in this case, and if Jack Smith wants your testimony in this case in relation to that memo that you are cited in, would you testify in this case? Would you comply with that?
Of course, I would comply with any subpoena, any request to testify. The reason I wrote the piece that I did in Just Security was that I thought all of us as citizens who have any information relevant to these charges have a duty to come forward and present it. And that's exactly what I did. I would be honored to say it under oath.
I want to go to one piece, the sort of shortest version of the Trump criminal defense. We'll listen to it now, presented by John Lauro, the First Amendment defense. Let's listen to this.
Every single thing that President Trump is being prosecuted for involved aspirational asks, asking state legislatures, asking state governors, asking state electoral officials to do the right thing. In fact, even asking Vice President Pence was protected by free speech. None of that is illegal.
Professor Tribe, your reaction to that?
It's hard to know where to start. I mean, that might work with some of the base listening, because words were used when Mr. Raffensperger was told, just find me 11,780 votes, or maybe you'll be prosecuted. That's an ask. Give me your money or I'll shoot you. I guess that's aspirational. Please give me your money or I'll shoot you. I mean, all fraud, all blackmail is committed with words. Conspiracies are agreements to undertake a coup use words. There is speech involved, but none of it is protected speech. And the indictment is extremely carefully written, not even to make anything of the president's incitement at the ellipse. There's no way I could have imagined taking the First Amendment out of this case more thoroughly than Jack Smith managed to do by his carefully crafted indictment.
Professor Tribe, we'd like to squeeze in a commercial break here. If you could please stay with us. We want to come right back to this discussion after the break. And when we do come back, we'll get Professor Tribe's analysis of a very strange order issued by the only judge presiding over a Trump criminal case who Donald Trump has not attacked. In fact, Donald Trump appointed that judge, and we will show you why he likes her even more this week than last week. That's next. Today on Twitter, former federal prosecutor Andrew Weissmann, a frequent guest on this program, suggested the possibility that the federal judge appointed by Donald Trump, who is presiding over the federal criminal case against Donald Trump in Florida, got her latest idea by watching TV. Andrew Weissmann points out that the day before the judge issued a very strange order in the case, the Fox propaganda channel had a discussion of how unusual it was for Jack Smith to have presented evidence to a grand jury outside of Florida in that case. Judge Aileen Mercedes Cannon, who was appointed by Donald Trump, told Jack Smith's prosecutors and Donald Trump's defense attorneys to file briefs to, quote, address the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or seek post-indictment hearings on matters pertinent to the indicted matter in this district. Donald Trump's defense attorneys did not ask the judge to do that. No one did, except possibly people she might have heard discussing it the day before on a Trump-supporting television show. Professor Lawrence Tribe is back with us. Professor, your reaction to that order by Judge Cannon?
My reaction is I couldn't, for the life of me, figure out what she was doing. It's not a thing. There's no rule, no practice, nothing that suggests that you can't use another grand jury where some part of the illegality might have occurred in order to generate information for a criminal investigation. It was sort of like what Aileen Cannon did the first time when she just out of the blue inserted herself into the process of just sort of sorting the documents and overseeing the search. So I had no idea where she got the idea. As you point out, it wasn't ever suggested even by Trump's lawyers who make the craziest arguments, but they never suggested that there should be a delay to address this non-issue. Andrew Weissmann deserves great congratulations. He had his Sherlock Holmes cap on. He was looking around and he figured out the only possible place she could have gotten the idea was on Fox News, where an ex-lawyer for the ex-president came up with this bizarre question that really isn't relevant to anything. So she just showed her true colors. She was obviously trying to delay things for Trump. And in a way, it may have backfired because as that trial gets postponed, a space is open for the really most important trial, the one that could go forward quite quickly with just one defendant. The co-defendants, including Mr. Chisborough and Giuliani and all, they'll probably be indicted separately. But the one big trial for trying to overthrow the country and overthrow our democracy, it can now go full speed ahead while Aileen Cannon figures out how to clear the lane, thinking she's doing a favor to Donald Trump, I guess, but in fact creating space for the trial that can happen fastest under the most competent of judges, Tanya Chutkan, to go ahead. So in a way, it's sort of poetic justice.
It is an interesting tale of two judges. And as we saw tonight, Judge Chutkan is moving as fast as she possibly can in her courtroom in Washington, D.C.
Right. While giving fair time to the defense. She is a former defense lawyer. She's trained in important values of due process. She's a judge with an impeccable reputation, and unlike Aileen Cannon, who doesn't really seem to know what she's doing, this judge knows exactly what she's doing, and she's terrific at it.
Harvard Law Professor Lawrence Tribe and potential future witness in the prosecution of Donald Trump in Washington, D.C.
He doesn't need me as a witness.
I know. I know. He probably wouldn't need you anyway. With the memo, he could make it very clear without a witness what the real words of the memo were. Professor Tribe, thank you very much for joining us tonight. Really appreciate it.
Thank you, Lawrence.
Thank you.